in the face! Thank you.
Hello and welcome to Hey, Not the Face with your host, John Nash, and your producer, me, Steffi Haynes. And this past Friday, we got sort of some big news because there was a status conference for the antitrust settlement. And there was a whole bunch of stuff that happened there that we are going to talk about. But first, let's check in with John and see how he's been doing for the past week.
Well, for the week, okay. For the past few days, busy following up on the story because we do not have a live feed to that hearing that we had Friday. We don't have a transcript. And very few people covered it. So I was on the phone trying to talk to as many people that were there as possible to get the rundown of what happened.
Oof. All right. Well, before we jump into that, though, we do have one question that pertains to Dana White's Fox interview. So let's get into that first. Now, he told them that CBS was very close to buying the company several years back and that they were going to buy it for about $1 billion, but it fell apart when he got into an argument with Showtime executives. Now, do you have further details about this? Because you are quite entrenched with Showtime.
Well, I wouldn't say I'm entrenched with Showtime, but there are people
with people
in
from
the industry. I do know some people. This is actually surprised. This was going to be a question last week. Remember when we talked about the Dana White Fox interview, but we nixed it off the air because I didn't know the details. I said, let me ask around. Let me know if we know anything about this sale, this story, because I'd never heard it before. And lo and behold, I asked around, and a Showtime sports representative I spoke to says that none of their then, considering must have been an older story, right? Let's say it doesn't even have to be then, from 2006 until the end of Showtime, none of their senior executives during that period recall any conversation or situation similar to the one White described. That's what I was informed. So I'm not saying White's not right, but no one on the Showtime sports side seems to remember this happening at least the way it happened, the events as he's described happening at all.
I'm not saying White's not right, but I am.
I'm going to guess now. I don't believe the story's accurate that I don't believe the CBS was close to buying Showtime. I have, in some ways, I think he's conflating, because I do remember another story he told where he got in arguments with the Showtime executives.
Yeah.
But it was about something other. So my guess is that he's conflating one call about something else with this call and putting it together and making a much more entertaining story. And it is kind of remarkable that I saw a lot of coverage of this, but I didn't see anybody following up to ask people around, did they recall this happening or did it happen?
Well, that's what we're for.
Yeah, but also shows you, I think, not the MMA media. I'm not going to rag on it because it's, the people are working and they're doing their stuff, but the trend in it has been moving more away just to generating the content than follow up. This is something like Trent Ryan Smith would be just going nuts. We got to follow up and ask anybody if we know anything about this.
Yeah. All right. So let's go ahead and get to Friday's status conference. Now, what was it regarding? And did the judge give us his ruling regarding the preliminary settlement?
Well, what was it about was we had a proposed settlement plan between the UFC and the plaintiffs, the fighters. And the judge in the preliminary approval phase where, the judge is supposed to most people assume that he would sign off on it. He said he did not agree with the settlement. He had reservations about it, concerns. And so he gave the parties a chance to submit more evidence, more material to convince them, plus a new proposal. He looked at this, sat down, and apparently they did not convince them because the judge did not give a ruling. He did not approve the preliminary settlement. He didn't deny it, but it did sound like he's strongly leaning towards denying the settlement plan. So that's where we're at on that.
So what seems to be the problem here? Why does he have issues with the settlement? And what are the divergent interests between the Lee class and the Johnson class members that was mentioned by Josh Gross, who happened to be there?
Yeah, we should really, compliment the people that were there. Court News Service, Courthouse News was there. Josh Gross was there covering it publicly this time. Paul Gift was there, but he didn't tweet about it. Josh did that. And then there was a few other witnesses. I think Kung Lee was there and his wife, just a handful of people. So if they weren't there, we wouldn't have any details at all. So, and I was, like I said, I was on the phone over the weekend talking, communicating with a lot of these people, trying to get a breakdown. Some heard a piece of it and then I'd go to another person and get more fleshed out details. So I wasn't there, so I could be wrong about some of the stuff, but I think the stuff we're going to talk about today is the stuff that most of them all agreed was said during it. So anyways, the problem for the judge is fourfold. First of all, we'll talk about there's the divergent interest between the two classes, the Lee class. So people, who I'm sure most people who listen to this are familiar with this case, but just to be brief, the Lee class was the first class that filed an antitrust complaint against the UFC. They did it back in December 16, 2014, because of the statute of limitations. The case starts from December 16, 2010, and that went to June 30th, 2017. The other class, the Johnson class, was filed that covers from July 1st, 2017 until now. So that's the two classes. He's saying there's a divergent interest because the Lee class does not have injunctive relief as part of their class. In other words, the court can't force changes to the business practices of the UFC. They are seeking damages because all their fighters, that was a period in the past, and basically almost all the fighters during that period are retired, no longer fighting, or there's no interest in them continuing to fight. If they are fighting, they're now in the Johnson class. So their interest is damages only to get as much money as possible. The Johnson class, though, includes active current fighters. And it's in their interest to get injunctive relief, aka contractual changes or protections that would give the fighters more freedom. And so that's the split. One class is interested only in damages and want to settle. The other class, according to the judge, their interests seems much more likely that they'd want injunctive relief changes to the business model. The other problems that he brought up is the monetary damages are insufficient, according to him. Boulware addressed the amount of money awarded to fighters in the settlement and how it's to be distributed. And it's compared with the fighters who went to trial with treble damages, it was very low. So he was pointing out that even for the Lee class, the damages they could get are much lower than what they were asking for when he certified the class. And then many of the Johnson class members, this is the third thing he brought up, many of the Johnson class members signed class action antitrust waivers that are now in UFC contracts. And this is an issue because the judge is concerned that due to the waivers, many current fighters won't receive any meaningful settlement for damages or in changes to contracts. And then the final thing is the Boulware discusses the plaintiff counsel. They might have kind of a conflict of interest because they have an incentive to settle the Lee class instead of pushing with the Johnson class. So there's kind of a conflict. The same representative of both parties, both classes, but there's a conflict between the two classes that can cause a conflict with the representation. So those are the four big things that he brought up.
Did he give any hints what he wants to see done here?
Well, this is where we kind of open up a can of worms with this case, because it sure sounded like, based on what everybody said, the tweets, the articles, the comments, it sure sounds like he's suggesting they split the classes now. They don't settle together as a class; they split them. And so the Lee class can either try to settle on their own, but according to the plaintiffs, and the UFC will not settle Lee by itself. It's all or none. So if they won't settle, then the Lee class would go to trial. And then also he's suggesting that they go forward separately with Johnson as a separate class. And that one would mean they would probably, and then they also, as part of it, because so many signed waivers, they would have to challenge those waivers in court. So that's the two things, which is much different where we are now trying to settle the case. He's saying go to trial with the Lee class and then go ahead with the Johnson class, which includes getting over the hurdle of challenging those waivers in court if necessary.
Why do the plaintiffs' attorneys so badly want to settle instead of going to trial where they could make a lot more money?
Well, hypothetically, they could. It's conditional, right?
Mm-hmm.
Okay, this is going to be a long answer for me. For one reason is they want to get paid, right? Besides for Rob Mazie, who's kind of a crusader on this, all the other attorneys, this is their professional class action attorneys, right? They specialize in antitrust cases. They are here it's a business, even though if they're representing plaintiffs and they have to represent them in their best interest at the same time. So if you look at it that way, they put in 10 years, now more than 10 years, because this started before they even filed the complaint. They had to do reports, write up. So for over 10 years now, they've been working on this case. They've spent tens of millions of dollars out of their own pocket paying for experts, travel, all that stuff. They've also accrued tens of thousands of free labor because they only get paid if they win. So you can understand they're like, well, this case is dragged on. We'd like to get paid. So that's one thing. But on two, the other problem is they're concerned, it sounds like, they're concerned that a trial is a risky proposition for them. And most antitrust cases, most class action cases are settled. 70% are settled before they even get through class cert. 95% of them never see trial. Why? Because if you get that far, the threat is usually so great for the defendant that they settle. The problem here is that the plaintiffs, they lost their big weapon against the UFC. It's not damages, it was injunctive relief. Because this case got delayed so long, and let's not forget, the judge originally said he would grant class certification back on December 14th, 2020. He said he would have his written opinion out. It was over almost 3 years later that it finally did come out. Because it was delayed so long, we split the class and injunctive relief moved to the second class. Because there's no injunctive relief, they don't have that big threat to the UFC. And so a trial with damages the UFC would be facing, which sounds like a lot, but one thing I remember is in a federal antitrust, in a federal class action case, you have to get all 8 jurors on this to agree with you. It has to be unanimous, their decision for the plaintiffs. So if there is one juror that votes against the plaintiffs, you lose the case. You don't win. And that's the risk of going to trial. And so you want to go in there with this weapon of huge damages and injunctive relief to force the defendants to say, we don't want to take the risk. Here, the UFC is willing to take the risk, it looks like, because, and apparently too, according to Zach Arnold and other reporting, they've done mock jurors. There is a percentage of the population that always side against the plaintiffs. And I think we see them on Twitter all the time, the fan base. There are certain people, you signed the contract, right? I'm surprised by this. I would have thought that it would be a slam dunk for the fighters because you're presenting beat up, poor fighters against billionaires. But apparently there's a segment of the population. Now, let's just say that segment is 1/6, like a Russian roulette. You got a 1 in 6 chance that anybody could be one of those people. Well, if you have 8 jurors, that means you only have a 1 in 4 chance of winning the case. And so that's the other problem. They're looking at it like, this is very risky for us who have now put millions upon millions and 10 years in this case to go in to a trial that we might feel like we have less, we're not likely to win. And if we do win, maybe we do get a much bigger settlement, but then you face the problem is you got to go through the appeal process. So any sort of award would still be years down the road. So from their position, they're like, we would think the best move now is to settle now. Unfortunately for them, the only way you can settle is if you settle Lee and Johnson together. And what makes Johnson acceptable for them to settle is because there's all these class action waivers that were signed in Johnson that makes that class very hard to win a case as well.
Real quick, can the UFC rescind the settlement themselves? Like, can they smell blood in the water and go, you know what? We don't want to settle now. To access the bonus content of this episode, you must be a paid subscriber. To do that, go to heynottheface.substack.com and subscribe today.
Ow! Ow! Not the face! Ooh! Ooh! Okay, the face!